2019, Your Lordship, Kumari versus ICC.
What is the urgency? What is the urgency?
The matter has been settled, Your Lordship.
Give a step.
Your Lordship, any day before Lok Adalat.
You want the matter to be referred to the Lok Adalat?
No, Sir, Your Lordship, before Lok Adalat.
Before Lok Adalat? Okay, give
And
a
Your
step.
Lordship, one more mentioning, MA number 98 of 2021 with MA number 24 of 2021. This matter also has been settled, Your Lordship.
Before the Lok Adalat, give steps. To be listed before Lok Adalat. The reference. What is the date?
9th year.
9th. It will be listed on 9th for referring to the Lok Adalat.
Under the heading for Lok Adalat?
Yes, under the heading for Lok Adalat.
This is miscellaneous appeal. This matter was heard earlier, Your Lordship. This is hearing matter.
Use this.
This
Yes.
is hearing matter arising out of probate case, Your Lordship. The urgency is that the lady, that the appellant is 58 years old, Your Lordship.
Sure.
That's the urgency. This matter was heard earlier.
So 58 years, what do you mean to say? 58 years is too old a person. That cannot be a ground.
This matter was heard.
It will hurt. It will take. Wait. You're seeing the situation. The bench is now half a day. Bench is now half a day. So you want bail also to be heard. You also hearing to be heard. It is not possible. Your grievances is that the bail was not being taken up. Is it not? Your grievance were that bails are not being taken up. It's been piled up. So you can't have the cake and eat it too. Decide what you want. Sorry.
And insurance company will for withdrawal matters.
Yes?
Withdrawal के लिए insurance company करती है.
You want to withdraw?
Right.
Withdraw. For withdraw.
Withdrawal matters.
Not tomorrow.
ये जो आपको because नीचे कोर्ट में सेटल करना है withdrawal के बाद.
You have settled it?
हाँ settle हो गया. There needs to be some compliances.
Okay, tomorrow.
For tomorrow.
Yes, call the list.
From supplementary call this, under the heading for hearing, MA number 351 of 15, Mr. Manoj Kumar Sinha for the appellant, Mr. Ramnivas Roy for the respondent.
My Lord, I am appearing for the respondent.
Where is the appellant? Where is the appellant?
This is part matter.
Yes, we should have been here. Who is the appellant?
Manoj Kumar Sinha, Mr. Manoj Kumar.
Where is he? What was the issue?
My Lord, husband of the petitioner is a porter in railway.
Okay, he felt ill and he left
Yes.
by boarding a power engine.
Yes,
And then he came down to relieve himself and then he was run over.
that's by goods spread. And all the retirement benefits as well as compulsory
Appointment
appointment.
also has been given, but
And the learned court will hold that the petitioner, husband of the petitioner not died within the territorial jurisdiction of the Gajhandi police station. Hence, he is not entitled for any compensation under the Workmen Compensation Act.
the Honorable Supreme Court has given an extended definition of the workplace. There are several judgments which says that if a workman at the time of coming to his workplace meets with an accident,
Yes.
then he is entitled to receive compensation, and when he is returning to his home after completing work, he is entitled for
Yes.
compensation. Now, and the facts of this case, whether that can be applied or not.
Duty of this portal is 4 p.m.
Okay.
8 a.m. to 4 p.m.
No. See, as far as I remember, the case of the claimant is that while he was working, while he was on duty, he was not feeling well. So he took permission of the in charge to leave the place so that he can go to the doctor.
Yes.
So he left.
Yes.
Now the difference is, if he would have taken the road route to go to his nearest places or to a doctor, the matter is something else. Now he has boarded a power engine, the engine,
Yes.
and he traveled to some place when the engine stopped at a red signal or something like that. He boarded, he wanted to relieve, then he ran out. Whether this can be said to be the extended workplace, whether he was authorized to board that engine to go to a particular place after his duty was over.
Not upright, but he.
You show me all these things.
Permit.
You show me all, Mr. Counsel, these all needs a decision. You show me, it's just, don't argue on facts. You have to assist on the points which I am raising, the extended workplace and all these things. The judge, these type of cases needs extensive research and judgments. I see both of you are empty-handed. And if I don't get any assistance from you, don't think that I will work for you people. Give me at least some assistance.
Yes,
This is not a case which can be solely heard on facts. What is the question of law? Tell me.
Kindly page 17 of the impugn order.
Forget about the impugn order, this is an appeal. What is the... Tell me the law point. Answer this. Whether it can be said that he was on duty. What is the judgment of the Honorable Supreme Court which says that while coming for duty and leaving this duty, if some accident takes place, he is entitled to receive compensation? Where are the judgments?
Yes, there is judgment.
Where is it?
It is not.
What is the proposition? What is the proposition? Show me what is the proposition. Whether you can fit in that proposition, then only you are entitled to receive the compensation, otherwise not. Now come to the Act. When is a person entitled to receive compensation? Where is it? Which section? Employees Compensation Act. Tell me. Come to section 3. If personal injury is caused to an employee by accident arising out of and in course of employment. Now define, now show that your case falls within this phrase, in course of his employment, arising out of and in course of his employment. Show me. Which cases will come under the purview of this definition? Show me. What is the law?
One more indulgence may be granted. For in these days,
Everyone is watching us today.
Yes, madam.
This physical court is also live streamed. Everyone is watching us.
In these 3 days, my lord, I was not
And
physically well.
see what impression we are giving. It's a basic simple thing. You have to come bring your case within this ambit of this. And the judgments.
My lord, on Monday, my lord, I will assist my lord.
It seems that the parties are not ready with the hearing, ready to argue this case. First up, prayer has been sought for on behalf of the appellant. You also have time?
Yes.
On behalf of the respondent. First up. Raise this case after 1 week. Be prepared with all.
From Delhi Court list, under the heading Orders with Effect, serial number 1, second appeal 145 of 18. Mr. Rajendra Ram Ravidas.
Yes. Yes, Mr. Counsel.
Two defects are there.
What are the defects? What are the defects?
In which I have taken the ground lordship for that the judgment and hearing passed by the dead person, hence the entire working of the lower court is declared to be nullity. So there is no need to file a substitution petition.
Yes.
No need to file substitution petition.
Why?
Because this is my ground. Respondent number 4 are there.
Respondent number 4 is dead.
Yes, sir.
When? What was his status before the first appellate court? What was the status of the respondent number 4 in the first appellate court? Or before the trial court? Why should we? Let him. Let him. When will he learn? When will he learn? Pass over.
Serial number 2, second appeal 153 of 18. Mr. Shaukat Iqbal, Mr. Mohammad Imran Hassan.
Yes?
There are two digits left out now. One is for complete participation has to be corrected now.
How much time?
Only 2 weeks have.
2 weeks has spread for to remove the defects.
Okay.
Serial number 3, second appeal 187 of 18. Mr. Sudarshan Srivastava, Mr. Sunil Singh for the appellant.
There is an IS-31 report 2019 for substitution of respondent number 1. And some of the defect has been removed, except 2 and 8, defect number 2 and 8. It has to be corrected by the learned court below. So,
The judgment and the degree be sent out to the court below for necessary corrections. To carry out necessary corrections in terms of the office notes.
Serial number 4, second appeal 201 of 18. Mr. A.K. Sani, Mr. Amitabh Banerjee.
I think for 2 weeks time.
2 weeks to remove the defects as prayed for.
Serial number 5, second appeal 204 of 18, Mr. Shyam Sundar.
2 weeks time is prayed for.
Serial number 6, second appeal 205 of 18, Mr. Suraj Kumar.
2 weeks has prayed for.
Serial number 7, second appeal 206 of 18, Mr. Jayant Kumar Pandey, Mr. Sergeant Shami Verma.
2 week time blocks.
2 week time blocks.
2 weeks has prayed for.
Serial number 8, second appeal 207 of 18, Mr. K.C. Mahato, Ms. Ruby Yadav.
No one appears. However, 3 weeks time is granted to remove the defects as pointed out by the officers.
It has to be sent to lower court for correction order, so it has come in the office now.
Okay. Take down. No one appears. Full stop. The judgment and the degree be sent down to the court below for making necessary corrections in terms of the office now.
Serial number 9, second appeal 210 of 18, Mr. Vinendra Kumar.
No one appears. However, 3 weeks time is granted to remove the defects.
Serial number 10, second appeal 212 of 18, Mr. A.K. Sahni.
2 weeks time. 2 weeks time to remove.
2 weeks time has prayed for to remove the defects. बोल दीजिए.
Under the heading for orders, serial number 11, first appeal 91 of 15, Mr. Yogesh Modi, Ms. C.C. Sinha.
It will be taken after the orders cases. After the orders cases. Yes. So in this case,
Yes, sir.
what is the matter?
Sir, दूसरे क्वेश्चन बस. Just ask you. It's not possible.
One IA is on the board matter for additional evidence.
You are representing?
Respondent number 1 matter. I have filed contract in IA.
You have filed a counter in the IA. Pass over as prayed for.
Serial number 12, first appeal 179 of 15, Mr. Dilip Kumar Prasad, Mr. Ajay Kumar Pathak.
Yes, sir. I think, my lord, the intent appeal has come on the point of valuation, my lord.
Valuation.
Valuation is 4.5 lakh.
Very less than 25.
Under value, my lord, in view of notification, my lord. It will be,
The appeal was dismissed in 2019.
dismissed on the point of abatement.
Then what happened?
That was thereafter heirs of the appellant has been announced by the Honorable Court and substituted and matter restored.
The abatement was set aside.
Yes, abatement was.
In similar order, in part with the Honorable Court, first appeal number 203/2018, first case of the passed by my lord.
That batch case, whether it will go before the court will or this.
Yes, and senior able to condition this in of APF for this one.
Yes. They are
Order
assisted.
dated 19/6/2019.
What is the, just a minute. Case number?
First appeal number 203 of 2018, Rajendra Chaudhary versus Brinda Chaudhary,
Dated
19/6/2019.
19/6/2019.
Yes, ma'am.
Now, where is the suit value? Where have you mentioned the suit value? Where is the decree? Let me see from the decree itself. Yes. 4,50,000 the suit value.
The first page value?
And the appeal is decree the original suit. Yes. Take now. This appeal is under section 96 of the Civil Procedure Code. Full stop. The suit was valued at 4,50,000. So was the appeal. Full stop. The pecuniary jurisdiction of the district judge earlier was
Up to 25 lakh.
no earlier.
Earlier. Order 2,50,000.
It was 2,50,000, which was enhanced to 25 lakhs by an amendment in Bihar, Bengal, Bengal, Assam, Agra, Bengal, Agra Civil Courts Act. Take note of that order. Full stop. Right. Judgment dated 19/6/2019, passed in FA 203 of 2018. In all similar matters where the pecuniary jurisdiction, after increase of the pecuniary jurisdiction, this court directed that the first appeals which are pending before this court and the value of which is less than 25 lakhs or less should be sent to the district judge, should be remitted to the district judge for transfer to the district judge for hearing and disposal. Full stop. Next para. This case is also governed by the aforesaid judgment, aforesaid order, taken order, not a judgment. Order. Full stop. Thus, the office is directed to transfer this case to the Judicial Commissioner Ranchi, who will hear the first appeal and decide the same.
Serial number 30, MA number 237 of 50, Mr. Ashutosh Anand.
This matter was taken up on the last date of 28/2/2022, and the resolution was given to observe that the further sum of 21 lakhs is not brought in the concerned officer. We had to talk with the concerned officers, but perhaps they are not. So this case may kindly be further next time. This is a case of insurance company where the insurance company is in appeal my lord, and quantum is under challenge.
Okay. counsel appearing on behalf of the insurance company submits that there is no scope of settlement. Full stop. That being so,
Settlement over the amount already awarded.
no settlement. Full stop.
Over and above the amount.
Over and above the
amount already
awarded. Full stop. Let this case come under the heading, appropriate heading.
Perhaps in the meantime,
Let it come.
Serial number 14 with serial number 15. Second appeal 308 of 16 with second appeal 299 of 16. Mr. Neeraj Kishore for appealing both the cases.
We have filed the application for substitution along with the elimination.
Who is appearing?
For respondent number 2 and 16 to 26 one.
2 and 26.
2 and 26. Who have died on 15/5/2021 and 4/1/2019 respectively during the pendency of this. I can also file the petition for continuation of delay. But the other side has already appeared in the matter.
Where is the, I'm asking, where is the other side?
He was here, just here, perhaps gone down.
Who? Pass over.
Serial number 16, second appeal 505 of 16, Mr. Shailesh Kumar Sinha.
Who is appearing on behalf of Pratima Kumari or Pratima Kumari? 1D. Who is appearing on behalf of 1D? Respondent number 1D. Are you appearing?
No.
Yes, you are appearing. In chamber of Mr. A.K. Sahani. Go through the office note. The respondent are directed to go through the office note and take necessary actions in terms of the same.
Serial number 17, second appeal 520 of 16, Mr. Sudhakar Pandey for the appellant.
My lord, in this case, one interlocutory application has been filed for conversion of Chowdas 2 days delay in filing of the same addendum.
Who is appearing? What is the ground?
My lord, it is not got knowledge about his case for dismissal. एक 2013 उसके बाद हम लोग पिटिशनर जो है बीमार रहे करीब 6 महीना तक 30/10/2013 तक। फिर उसके बाद जो है डॉक्टर के साइड पर जो है 30/14 तक जो है वो जो है बेड रेस्ट में रहे। तब जो है हमारे ऑफिस में ही आए थे 2015 में।
There is no sufficient ground to condone the delay of 1400 days. Delay is of 1400 days. That means how many years? More than 4 years? More than 4 years?
Near about above 3 years.
Huh?
Near about 4 years.
Yes. Near about 4 years. What is the explanation? What is the date of the judgment?
My lord, दूसरी बात इसमें बीच में बीमार पड़ गए।
What is the date of the judgment?
Yes, my lord.
What is the date of the judgment? Your limitation expired on 21/8/2012. So what is it? Let's see what is your explanation. So you got information on 31/3/2013. Okay, I also accept this. And from 31/3/2016 to CC applied on 6/9/2000. When was the CC applied? When was the judgment of the 1/4/2013. You are saying that you have received information. Okay. So then the next is 30/10/2013. There is a vague explanation that he fell ill from 1/4/13 to 36. Then you again fell ill.
I know 2016 को फाइल हुआ है। जबकि 9/10/12 तक में फाइल हो जाना चाहिए।
Who is Sudhakar Pandey?
Myself.
Yourself. So he came to meet you on 15 June 2015.
Yes, my sir.
Now read what have you written here. But the draft for appeal was not drafted due to his, within bracket counsel, that means yours, ring engagement. That means you are getting married. What do you mean by ring engagement? When have you got married, Mr. Counsel?
तो हमारा लड़की का रिंग एंगेजमेंट था।
किसका?
मेरा बेटी का था।
तो आप क्या लिखे हैं?
उसी के चलते हमने
बेटी का लिखे हैं कि आपका अपना लिखे हैं?
ड्यू टू मैंने हमारे परिवार में रिंग सेरेमनी
ड्यू टू हिज रिंग एंगेजमेंट।
इसी के चलते ड्राफ्ट नहीं हो पाया था।
तो ठीक है, 2015 he met you for the first time in 2015, but what is the explanation from 13 to 15? There is no explanation.
तो हमारे पास आए थे उस 4 जुलाई 15 को आए।
There is no ground at all, Mr. Counsel. Before that, I am dismissing this. Clear. This interlocutory application has been filed under Section 5 of the Limitation Act for condoning a delay of 1402 days. That is nearly 4 years in filing this second appeal. Full stop. The counsel for the appellant submits, next part, the counsel for the appellant submits that the appellant fell ill. The appellant at the first instance did not have any knowledge about the judgment which was passed against him. Full stop. He submits that no sooner he got knowledge about the judgment, he fell ill and remained ill for 6 months. He stated that after he recovered, he went to the office of the advocate to search the file. But again he fell ill for 6 to 7 months and was advised bed rest. And he could not meet his counsel. Full stop. He submitted that only in the December 2014 he got the brief from his counsel, and in January 2015 his wife fell ill till April 2015. He stated that only in July 2015 the second appeal was drafted.
हमको फीस नहीं दिए थे इसलिए जो है 2016 में फीस दिए तो हमने फाइल किया
drafted, but the requisite fees was not paid, and as such in 2016 May and in the month of April some fund was arranged. It is mentioned that again the appellant fell in the month of May 2016 and was advised bed rest, and ultimately the appeal was filed in 28 September 2016. He submits that there is no willful laches on the part of the appellant and the delay be condoned. After hearing the counsel for the appellant, I have gone through the petition. As noted earlier, there is 1402 days of delay. Full stop. The dates are very important, which has been mentioned in the petition. Full stop. 21/8/2000. The appeal should have been filed within 21/8/2012. Full stop. Which was not filed. The appellant, as per the appellant, he came to know about the judgment on 1/4/2013, as he was not aware of the aforesaid judgment. Full stop. even if this court accepts the aforesaid submission, but thereafter the submissions which have been made is not acceptable. Full stop. He states that once he received the information about dismissal of his appeal, he fell ill for 6 months, from 30/10/2013, 6 months till 30/10/2013. Full stop. There is no document annexed with this IA in support of the aforesaid statement. The statement is absolutely vague. Even the disease which he was suffering has not been mentioned. Further, he states that in November he went to the council to search his record and fell ill from 2nd of December 2013 for 6 to 7 months and was advised bed rest. Full stop. There is nothing on record to suggest that he was advised bed rest. There is no document in support of his aforesaid statement. He states that on 1/7/2014 he went to the office of the council to collect his brief, but the brief was not handed over as the clerk of the concerned lawyer was absent. Full stop. This date on which he goes to the office of the lawyer is mentioned as 1/7/2014. Full stop. The appellant states that thereafter he went to the office again on the last week of December 2014 and got the brief. So this fact clearly suggests that for 5 months he kept mum and did nothing. Yes, 2014 likhe na? 2014 kept mum and did nothing and took no steps. It is then mentioned that from January 2015 his wife fell ill, and as there was no one to see his ailing wife, he was there in his house till April 2015 and couldn't meet the lawyer. Full stop. Then only on May 2015 it is stated that he went and met his lawyer with a brief, and full stop. He states that he again came on 15 June when there was a ceremony in the house of the lawyer, as the appeal was not drafted. Thus the appeal was not drafted. Full stop. He again met the lawyer on 7th July 2015 when the lawyer asked for his fees, which was not paid, and the funds were arranged only on April 2016. So it has further been mentioned that from May 2016 the appellant again fell ill and he was advised rest, and he could only come in 20th August and only visited the council on 8/7/2016 for settling the brief, and on 20th August 2016 again he returned to the office of the lawyer and the appeal was filed on 28/9/2016. There is no document to suggest that during this period, as claimed by the appellant, that he was ill. There is no document to suggest that he was ill from month of May 2016, as there is no document. Full stop. The entire petition is vague and clearly gives an impression that a story has been implanted to cover up the huge delay of 1402 days. Full stop. There is absolute laches on the part of the appellants, and the delays and the grounds does not inspire any confidence upon this court in absence of a single sheet of paper in support. Full stop. Thus, this petition praying for condoning a delay of 1402 days, which is days. This petition which is vague, without any sufficient cause. Praying for condoning a delay of 1402 days is hereby dismissed. Consequently, the appeal, second appeal number 73 is also dismissed.
Appeal number 18, second appeal 584 of 16, Mr. Lalit Kumar Lal, Mr. Mayank Mishra, for the appellant.
Lordship, I am claiming for an advocate on behalf of advocate on record, Bilabdas Banerjee.
Who?
Bilabdas Banerjee, his name is appearing in the court.
Who is Mayank Mishra?
Mayank Mishra, Lordship, has left the profession and Bilabdas Banerjee usually practices in the civil court. He requested me to seek an advocate on his behalf.
Mr. Counsel? What is the decorum? If he has a court in the High Court, if he files a case in the High Court, it should be his priority.
And also one more thing, one more second appeal 41 of 97 is.
What is, for what purpose this case has been listed today under the heading for orders? You can assist.
Not yet, don't have the file, therefore I can assist on the family adjourn this case.
So since last 45 minutes you were sitting here, you have not asked for the file also to go through. You could have easily asked for the file from my office, from my court master. The court master is obliging everyone by giving the file. No one can say that. He is not handing over the file to anyone. And this is for orders. You only have to go through the office note and make your submission. You sit here for 45 minutes. Watching the court proceeding. Give me the file.
There are two ideas on board.
Yes.
One is for substitution of since the respondent.
Yes.
And one is for stay. The copy of idea of stay is not served on me. I am referring for respondent number 1. First, the IA, they have filed for substitution of the deceased respondent number 5, defendant number 1, Gulab Mohammed.
Yes, who is that? Respondent number?
But one thing I would like to point out, my lords, the deceased died leaving behind, they say, paragraph 3 and 4, that wife and daughter and other, but what are the details of those persons?
Where is the IA?
Yes.
IA number?
IA number is not with us.
2531.
They say for limitation, and then another they have perhaps for stay proceeding.
No.
Two IAs have
Where is the substitution petition?
They have served me a copy. I look at them, they have not. An application under order 22 rule 9 is served on. This is copy. Whether they have filed or not.
No, this is order 22 rule 9 petition is here.
Yes, there's two applications there.
There's two applications. There's one limitation application.
And one is for stay that we have not.
Who has filed this application? Who has filed this application?
Knocking man is
Huh? Where is the substitution application? Yes? Where is the substitution application? This is the appeal. Order 41 Rule 5 means stay. This is a copy of the judgment. So this is the substitution petition under Order 22 Rule 9.
As per
Where is Mayank Mishra has left his practice.
Mayank Mishra has left his practice.
Thank God he has saved many of his clients.
paragraph 342 are legal errors.
Even if I take that the wrong provision has been mentioned as Order 22 Rule 9, it should not be Rule 9. Some other provision under Order 22. But still, is this a substitution petition without giving name of anyone, with a prayer that the deceased respondent number 5 be substituted and the name of the legal representatives be incorporated? Who are the legal representative? Yes?
Okay, tell him to file one supplementary affidavit.
Supplementary affidavit? Take down. A petition has been filed for substitution, for substituting deceased respondent number 5. Full stop. This next line. This application has been filed under Order 22 Rule 9. Full stop. Rule 9 is not the appropriate procedure, appropriate provision. Rule 9 of Order 22 is not the appropriate provision to file a substitution application. Full stop. Even if this court condones the aforesaid mistake, as nomenclature has got no effect, giving a wrong nomenclature has got no effect, but still, I find from the entire petition that the prayer has been made to substitute the name of the legal representative in place of the deceased respondent number 5. Full stop. In this entire petition, there is no whisper about the names of the legal representative. Full stop. Thus, full stop, this application thus cannot be said to be a proper application praying to substitute the deceased respondent number 5. Thus, this application being IA number 2531 of 2020 is dismissed. Consequently, IA number 2531 how there is two applications as 2531 IA number?
Two copies are given to me, who are here, how they have filed, what they have
No,
filed.
there is the numbers.
So in paragraph 6 he has stated one more thing. Therefore, the present filing a separate petition under Order 22 Rule 4 related with Section 151 of substitution of names of legal people and deceased respondent number 5 dependent number belong.
That is not on the record.
Who is the legal representative? And similarly, the limitation application, take note. Similarly, the limitation application numbered as 2531, also numbered as 2531, is dismissed.
It's arising out of the partitions to there is no substitution. That is dismissed, the entire substitution is amended. So it may be hard be a case, there is a stay application, but however, as per my information, the final decree is also prepared and please.
No one is appearing. Yes, next.
Clear number 19, second appeal 632 of 60, Mr. K.K. Mishra, Mr. Sudhir Kumar Mahato, for the appellant.
Yes, people file of 19,
Yes.
deleting the name of the respondent number 1.
The legal errors are already on record. Already on record. Who is the legal heir? Only one son.
One son.
No wife. Take up IA number 1551 of 2022. This IA has been filed to delete the name of respondent number 1 as
IA number 7555 of 19.
7555
Of 19.
7555 of 19. What is this 1551?
During pendency of the subject matter, appellant number 1 has also been made.
Appellant number 1 is also dead.
Appellant number 2 is
1559. Take down 17555 of 19. This interlocutory application has been filed to delete the name of Chandramohan Prasad, respondent number 1 from the cause title, who died on 3/6/2019 during pendency of the second appeal. It is submitted that the legal heir of the deceased is already on record as respondent number 2. So no one needs to be arrayed as a party. Considering this submission, this application is allowed. The name of respondent number 1 be deleted from the cause title, full stop. Necessary corrections to be carried out in red ink within 3 weeks. Next slide. IA number 1551. Who is dead now?
26/2/2020.
Kalyani Devi.
I have employed this just
For IA number 1551 of 2022. By filing this IA, the appellant seeks to delete the name of appellant number 1 who died during pendency of this appeal. Next, but it has been submitted that the legal heir of appellant number 1 is already on record as appellant number 2. So there is no necessity of including anyone as the appellants. First up. Considering the safe submission, IA allowed. Name of appellant number 1 be deleted. Necessary corrections in writing within 3 weeks. Just execute it just now, just correct it. Within a week, within a week. And just do it. Give a red pen to him.
Serial number 20, second appeal 642 of 16, Mr. P.A.S. Pati, for the appellant.
I'm paying for the.
Yes?
I'm paying for the.
Yes.
There is a delay of 18 days. There is final invitation case. So continuing the delay of 18 days.
19 days. Issue notice.
18 days.
Issue notice to the respondents. Ordinary process requisites
Within 4 days.
3 weeks.
Serial number 21, second appeal 664 of 16, Mr. Yashwardhan, Mr. Ashutosh Prasad Joshi.
May it please the Lord. But this one again has been filed for continuing the delay of 12 days.
Notice. Four weeks ordinary process on the respondents.
Serial number 22, second appeal 669 of 16, Mr. Sanjay Kumar Tiwari.
Sir, I say for 2 weeks.
Why?
Because plans are not in fact, I have got information from the council of 14 that some moments have died.
Who has that?
With utmost circumstances,
Huh?
certainty I cannot say.
Huh?
With utmost certainty I cannot say. That I am very good. Plans are not in fact, at least in big losses.
On the request of the learned counsel for the appellant, list this case after 3 weeks.
Serial number 23, second of 675 of 16. Ms. Sarita Gupta, Mr. Abhijit Kumar.
There is an idea for controlling the limitation of 9 days, Your Lordship, and filing the substitution petition.
Yes.
And Your Lordship, also filed the substitution petition by idea number 9658.
Yes.
And idea number 9659 has been filed for controlling the delay of 9 days.
But notice has to go for condemnation also. Notice ordinary process, the respondent, number 1 to 7, requested 3 weeks.
Serial number 24, second of 699 of 16. Mr. Rahul Kumar Gupta, Mr. Kisle Kumar.
Your Lordship, we have filed an IA 2092 for continuation of delay 33 days.
How many respondents are there?
Total respondents 45.
45 respondents. Requisites.
Including for former respondents.
No, for former respondents, they have to appear also. Notice ordinary process requisites 6 weeks.
Thank you. All right.
Serial number 25, second of 255 of 19. Mr. Sandeep Verma. Ms. Ritu Kumar.
This second appeal is admitted, second appeal matter. While order dated 19/11/2019, LCR was called for matter. The respondent has filed an application for vacating this stay. For that purpose, it is come.
2008 volume 10 SCC. 2008 volume 10 SCC. LCR. LCR has not been called for. Huh? What was the suit?
Eviction suit. But the appellant filed an application under order 21/97.
Yes.
That was rejected after taking the evidences. Against that appeal was referred. That too was rejected, my lord. Thereafter the second appeal.
What is your ground? What is the perversity in the judgment?
My lord, let matter, criminal matter may be heard on point of merit, my lord,
Page number. What is, you have said that there is a perversity. The point of law has been formulated that there is a perversity in the judgment. What is the perversity in the judgment, I am asking? Which part of your evidence or which document has not been considered or which law has not been considered? You read the point of law which has been formulated, page 796. What is the point of law which has been formulated? Yes. Read that. No, let him read. He's a free.
And my date, my lord, a date, my lord, any date, my lord, immediate date, we shall argue the matter of merit.
You are not claiming independent title.
Sorry, madam.
You are not claiming independent title. You did not claim any independent title. You are claiming through the tenant. Your document shows that you are claiming through the tenant. BBC Act. Jharkhand Building Lease Rent and Eviction Control Act. How do you wriggle out of section 12?
That is there. My only player, my lord, that this case may be
Tomorrow? Or when do you want? Tomorrow or when do you want?
Next week, my lord, I was just praying, my lord. On the same day.
Okay, on the same day?
My
10th March, on the request of the Learned Counsel for the appellant, as he makes a prayer that this entire second appeal should be heard and the dispute be finally decided, which will benefit both the parties. Come on. This court fixes this case to be heard on 10th as the first case at the top of the board. LCR is not there. The office is directed to which place?
सिविल मिसलिनियस अपील 11/2019 में कनेक्टेड है.
Call for the entire lower court records of civil miscellaneous appeal number 11 of 2019 and also of eviction suit of Appeal on the civil miscellaneous call for the records of civil miscellaneous appeal number 11 of 19 and civil miscase 43 of 18
eviction suit E 2000
arising out of eviction suit
3 of 2010
3 of 2010. First of the court below will also forward the entire copies and entire records of eviction suit number 3 of 2010 also. So let this order be faxed immediately to the principal district judge Jamshedpur so that all these records can be sent through special messenger before the date of hearing. Tell your client to search for other recommendations. you understand very well.
There are three possible cases. Shall I call them? One
Yeah.
from orders for defect and two from.
Yes. Possible.
Possible matters, serial number 1, under the heading orders with defect, serial number 1, second appeal 145 of 80. Mr. Rajendra Ram Ravidas, Mr. Ayush Aditya.
Yes. Now tell me, who died when? Who died when?
Respondent number 4.
Now first tell me what is the office defects.
Office defect is also to substitute the respondent number 4. In grounds lawsuit serial 1 for the judgment and decree passed against the dead person.
No, defect number 10, it appears that as per para 1 of the grounds, respondent number 4 to 6 of degree under appeal are deceased. And respondent number 7 and 8 of memo are the legal heirs.
Yes, sir.
7 and 8 are legal heirs.
No, Your Honor. 7 and 8 are not legal heirs. Yaqub died in leaving behind Juveza Khatun and one.
4 to 6 are dead. So 4 to 6 died when?
I don't know that during the pendency of appeal, Your Honor.
Who are you?
I am the case of Sajid Mia.
No, before the appellate court. And who are these?
Respondent number 3, Your Honor. Sajid Mia.
You were respondent number 3.
Yes.
And these were respondent number
4.
The 4 to 6 were appellants or respondents?
No. Appellant, Your Honor.
They were
Sir,
appellants.
respondent.
They were also respondents?
Yes, yes. No.
They were not substituted?
No. They are not substituting during the pendency of this appeal, Your Honor. For that reason, Your Honor, I have taken the first ground.
No. What was the suit for?
Suit of partition.
Suit for partition. Who are the legal heirs of those?
Legal heir
Who
of
are the legal heirs of those respondent number 4 to 6?
respondent number 4, Your Honor. Javeda Khatun, son of family Samim, and Idris died leaving behind Abdul Ghaffar and Ilyas Yusuf.
You informed this court about who are the legal heirs of those? Yes?
So far as respondent number 4 is concerned, but he died leaving behind one daughter and one son, Zubeda and Muhammad Shamim, who are not party in the decree under the appeal also.
Okay.
And so far as note 5 is concerned, Muhammad Idris, he died leaving behind legal heirs. They are party in the decree under the appeal and in memo of appeal also. And so far as respondent number 6 is concerned, Yusuf, he died issueless, that has been mentioned in the first round. So notes 4 to 6, these are the.
So 5 and 6, it's no problem.
5 and 6 is no problem. 4 I have taken as well.
So far as this is a partition suit.
No, this is not a partition.
You are saying it's a partition suit?
No, this is not a partition. This is suit for declaration of right title interest. Your Lordship may see page 16, trial court judgment, but first time, the plaintiff has filed this suit for declaration of right title interest and degree of consolidation of possession. So, my prayer would be so far as defect number 10 is concerned, but that will not be a defect, because that is a ground available to me. Although not I have a good case, I was prepared for this order 41. I mentioned this matter on the virtual court, because these are defects and it came under.
The defect number 10 is ignored for the present. What about defect number 12?
But that I will just remove during both.
The counsel for the applicant submits that he will remove the defect number 10 and defect number 12.
But I see there is an idea for limitation, but notices will have to be issued.
First remove the defect then.
I will just now remove it. It is only
issue notice on the point of limitation to the respondent.
Only one respondent or one
respondent by both process requisites 1 week.
1 week. Alright. But this is a very technical thing, Doctor.
Under the heading for order, serial number 11, cross copy 91 of 50, Mr. Yogesh Modi.
Yes. Orders with defect or IA?
It's an order.
Well, Lordship, my senior is on another board. I will short pass, but not.
There is a petition under Order 41 Rule 27. Order 41 Rule 27. An application has been filed.
An idea has been filed for reducing additional area, counter area.
Yes. Where is the petition? Yes. So you want to bring an FIR as an evidence. What is the evidentiary value of an FIR?
Yes.
To show what? What do you want to prove by an FIR?
Yes.
That simply a complaint has been lodged.
Yes.
Now whether the complaint is of any substance or not, that this court cannot decide.
No, the state that was opposing me that I was not the rightful claimant of the land which was acquired by the state. Numbers may kindly have looked to the FIR in which the state during investigation found that yes, I was the correct claimant with regard to the land that was acquired.
What is the evidentiary value of an FIR by itself?
But the payment was made to two persons who were.
I am asking a simple question.
Yes, Lord.
In criminal law also, you appear in several criminal cases. Just tell me what is the value of an FIR?
It's just first information to you that an occurrence has taken place.
Some offense has taken place,
yes,
which needs investigation.
Yes.
And thereafter trial. If your charge sheet is filed. So how will this help you? So how will this help you?
By this affair, I just want to show that the correct element, not only this affair,
this FIR, on the basis of an FIR, you cannot become a correct
that was
claimant.
made to the other
Mr. Counsel, on basis of an FIR, you cannot become a correct claimant. You have to prove by evidence. What evidence you have led?
So far as the
what evidence you have led during the land acquisition case? You had an opportunity.
Yes,
the
land was acquired by my father, and he had given
so it will be based on the same evidence.
Yes.
So this FIR has got nothing to do.
No.
So I'm dismissing this order 41 rule 27 petition.
Let me seek instruction whether after what is the result of this investigation in this FIR. So far as seeking instruction on this point is concerned, so that I could, if I have to file.
Not only investigation.
Pardon?
What happened in?
Yes.
Trial.
That I have to seek instruction.
Now, the second question is:
yes.
Can the criminal court give a declaration that you are the heir or you are the rightful claim owner? And a criminal court give this declaration.
The payment that was made to respondent 1 and 2 was not wrong. That was the wrong payment made to respondent number 2 and 3. Sorry, 2 and 3.
Can suppose the criminal court, this respondent number 2 and 3 are accused in this case?
Yes.
Suppose they acquits them, then suppose they acquit them, then and holds that amount of compensation was correctly paid to them, then
that would be one.
Then let me check up this angle also.
And then
If I are
given liberty to withdraw this IA, with liberty to file if any other, the result of the criminal case, if any, so occurred after the trial.
What is order 41 rule 27? Read that.
Production of additional evidence in appellate court. The parties from appeal shall not be entitled to produce additional evidence whether order or documentary in the appellate court, but if A. the court from whose issue the appeal is preferred has refused to admit evidence which ought to have been admitted, or AA. the party seeking to produce additional evidence establishes that notwithstanding the exercise of due diligence, such evidence was not within his knowledge or could not, after the exercise of due diligence, be produced by him at the time the decree appeal against was passed, or B. the appellate court requires any document to produce or any witness to examine to enable it to pronounce judgment on or for any other substantial cause.
So you are not covered by A or AA.
Yes.
You at best you can come under
B.
B.
Yes.
So you read B again.
The appellate court requires any document to be produced or any witness to be examined to enable it to pronounce judgment.
So FIR cannot be said to be a judgment which is necessary for pronouncing a judgment that whether you are a legal heir or not. You are claiming on the basis of a legal heir?
Yes.
So finished. Dismissed. Legal. Yes, definitely. Not the main one. Take down. IA number 3723 of 2015. This is an application filed under Order 41 Rule 27, read with Section 151 of the CPC by the appellants. Full stop. By filing this application, the appellant seeks to bring on record as evidence, as additional evidence, the FIR registered as Dhanbad PS case number 212 of 2016 under section so and so of the Indian Penal Code and so and so of the STSC Act. Next para. The counsel appearing on behalf of the appellant by moving the aforesaid application submits that this FIR is an important piece of evidence which needs consideration of this court to prove that the appellant herein are the legal heirs of the landholders whose land was acquired, and they are only entitled, and only they are entitled to receive the compensation amount, and not the respondents. Respondent 2 and 3. He submits that this FIR has been filed at the instance of the state, as the state felt that the compensation has wrongly been paid to respondent number 2 and 3. And a forgery has been committed by paying the state compensation. Next para. After hearing the learned counsel for the appellant, I find that this application is filed under order 41 Rule 27 of the CPC. Next para. Order 41 Rule 27 of the CPC provides for recording additional evidence at the appellate stage. Full stop. If we read the provision of order 41 Rule 27, we find that normally the evidence, additional evidence will not be accepted at the appellate stage until and unless the case falls within the purview of 27(1)(a), small a, then comma small aa, and then b of the provision of law. For better appreciation, it is necessary to quote Order 41 Rule 27. 1. A, AA, and B. Full stop. Next paragraph. Only if the appellant can bring his prayer within the ambit of these three subsections of Rule 27, then only his prayer can be allowed. Next one. To appreciate the case of the appellant, I find that he wants to establish that he is the legal heir of the land user by bringing on evidence, by bringing on record the FIR as an additional evidence. It is not a case that it is admittedly not a case of the appellant that this document was refused to be admitted in evidence by the trial court or the tribunal. Thus, this case will not be covered under 27(1) small a. Full stop. It is also not the case that of the appellant that he could not produce this document as evidence in spite of due diligence and in spite of exercising due diligence, as such as and the said evidence, said document was not within his knowledge when the decree was passed. When was the decree passed? Full stop.
15.
Full stop. Admittedly, this FIR is of 23rd February 2016, and the award of the tribunal is dated 14/5/2015. Thus, this FIR was instituted much after the tribunal passed its order, passed the award. Thus, the next paragraph. The only provision thus which the appellant is taking resort to is 27, Order 41, Rule 27, 1 within bracket small b. Full stop. This provides, full stop, the aforesaid provision provides that a document can be taken in evidence as additional evidence at the appellate stage if the appellate court requires any documents for pronouncing the judgment or for any other substantial cause. In this case, the main issue which the appellant has raised in this appeal is that they are the legal heirs of the deceased and are entitled to get the compensation and not. And respondent number 2 and 3 are not the legal heirs and they are not entitled to receive the compensation. To prove this aforesaid fact, the aforesaid fact cannot be proved by an FIR, by a first information report. It is the evidence which the parties have led before the court below which will decide this issue. Furthermore, an FIR is not a substantial piece of evidence. Thus, no useful purpose will be served in admitting this FIR in evidence. The case of the appellant, the prayer of the appellant do not fall within any of the provisions, any of the exceptions, any of the provisions laid down in Order 41, Rule 27 of the CPC. Thus, I find no ground to entertain this application. This application thus stands dismissed.